Hello, everyone. Thank you for joining us in our complimentary webinar series for U.S. federal government contractors. We're coming to you live from Washington, D.C. today. You probably found out about today's webinar through our newsletter, which reaches over 23,000 federal government contractors and service providers. Today's session is complimentary and also recorded. You can find the recording on our website and YouTube channel about 24 hours after the webinar, though usually even sooner. We have over 540 complimentary webinars on our YouTube channel. This includes all 52 parts of the FAR, all 52 parts of the DFARS, and hundreds of webinars on strategic and tactical topics. If you'd like to advertise in our newsletter or in any of our upcoming webinars, please email us at hello@jenniferschaus.com. And a little bit more about us. We are a specialized consulting firm focused on working with established federal contractors. We work with product, service, and software firms across the globe. For more information about our services, please visit our website and select About Us. As I mentioned, today's webinar covering the FAR supplements is complimentary and recorded. We began this series in January 2022, and you can find the past recordings on our website as well as the future schedule with the registration links. And here's just a look at what we've covered so far. We're almost done after today. We only have 2 more FAR supplements. And then here's just a look at our Friday schedule. On Fridays, we cover the same agency or department that we covered in the FAR for that week in a Playbook series. So we discuss upcoming bidding opportunities, contracting trends, small business resources, and we often feature a government speaker. Again, the full schedule and past recordings are on our website. You can look at the Playbook tab. Please join us for our specialty webinar series covering executive orders, House and Senate committees, and how they impact federal contractors. These are complimentary webinars and they will also be recorded. Registration links are within the slides and they'll be sent out after today's webinar. And we also have added one more procurement playbook webinar, except it's not on a Friday this time. We'll be doing business with NSA. This is going to be a live webinar only. It will not be recorded. The slides will not be available afterwards, so don't miss this rare opportunity to participate. And the government speaker will be taking audience questions during this webinar. So we really hope that you can join us. This webinar will be on Tuesday, August 30th at 12 p.m. Eastern. And please note, we will be starting our subcontracting webinar series on September 7th with the Department of Agriculture. We'll be going through top vendors and subcontracting opportunities, as well as the legal perspective. So please join us for that. You can find the registration links for that under the subcontracting tab on our website. And now we'd like to take a quick moment to thank our sponsors. We'd like to thank the Virginia PTAC. Virginia PTAC is based out of GMU in Fairfax and offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on business location. If you're interested in learning more, please use the links provided to explore what PTACs can offer. Next, we'd like to thank the Federal Business Council. The FBC creates and manages virtual and in-person meetings and events to connect industry and government thought leaders, product providers, and solutions with government programs that use them. The FBC works with a variety of federal agencies to connect government and industry in the form of in-person and virtual conferences, training events, policy dialogue, and outreach. Over the last 40+ years, FBC has become a comprehensive resource for connecting industry and the federal government. Next, we'd like to thank Dastin. Dastin is an IT and cloud solutions provider working with corporations, the military, and government agencies to lower their costs, increase scalability, improve operational efficiency, and meet compliance regulations using targeted cloud-based solutions. Dastin is a certified partner of Oracle NetSuite, a premier tiered Google Cloud partner, and certified partner of Cisco, Virtue, AO Docs, and Authenticate. For more information about Daston services or to schedule a complimentary consultation, please email Joe Alston or visit the Daston website. Next, we'd like to thank C3. C3ISIT develops tailor-made technology solutions that increase efficiency, bolster productivity, and improve business processes. C3 is the leading provider of managed IT services as well as compliant cybersecurity solutions for federal contractors. C3 works with defense contractors to achieve and maintain CMMC 2.0, DFARS, and NIST 800-171. Contact C3 to learn more about the CMMC 2.0 Readiness Program. The contact information is on your screen. Next, we'd like to thank Rlj Financial. Founded in 2008, Rlj Financial Consultants is a customer-focused, quality-driven, minority and locally owned provider of commercial insurance brokerage services. Their services are designed to maximize your return on investment and managing the risk to your business. Call Roderick today at 202-832-1417 for a free consultation and insurance quote. And lastly, we'd like to thank the PubK Group. The PubK Group publishes news and insights for government contractors, agencies, and counsel. Every day, PubK delivers news on bid protests, contract disputes, new laws and regulations, cybersecurity requirements, False Claims Act activity, and developments in mergers and acquisitions in the GovCon community. In daily news briefs and in-depth conversations and podcasts and webinars, PubK leverages its deep bench of government contract experts to keep you up to date on the fast-changing government rules and expectations. And every January, PubK presents its week-long annual review featuring more than 50 GovCon experts across a dozen panels, recapping the year's top developments. Participation and CLEs are free to subscribers. Visit PubK online at www.pubkgroup.com. All right, thank you again to our speaker and attendees for joining us today in our FAR Supplement series. Today, we will be covering the FAR supplements on the Nuclear Regulatory Commission. So let's meet our speaker. Our speaker today is Erin Felix, and she represents the firm Polsinelli PC. And as a reminder, we don't take any questions. So if you have any questions for Erin, her contact information is on the screen there, and you can contact her directly. So thank you so much for joining us today, Erin. I'm going to put myself on mute, and I'll wait for your cue for the next slide.
All right, thank you, and thank you everyone for joining us this afternoon. Please, you can go ahead and advance to the next slide. Thank you. So as the intro said, we are here today to talk about the Nuclear Regulatory Commission Acquisition Supplement, or as I have always heard it pronounced, the NRCAR. There can always be some debate about whether you pronounce the letters or whether you pronounce the words or how you do it with acronyms. But for purposes of today, and at least from my experience, we're going to go with the NRCAR on this. The NRCAR is codified at 48 CFR Chapter 20, and you'll see that as we talk about the numbering scheme for the supplement. But as it's named, this is a supplemental regulation to the Federal Acquisition Regulation. So the NRCAR is not by itself a complete document. When you're looking at NRCAR acquisition regulations, you have to look at them in the context and on top of their analogous FAR provisions. The FAR and the NRCAR apply to essentially all acquisitions by the NRC that relate to obligated funds, obligated and appropriated funds. So much like the FAR, the NRCAR does not apply to non-appropriated funds procurement. Next slide, please. Structurally, the NRCAR is set up the same way the FAR is, which you would expect. So there are 8 subparts in total, and you can see them delineated here. Importantly, the supplemental regulations, there are a number of them throughout the NRCAR that I would say simply reiterate or minimally tailor the FAR provision. So for example, there are provisions that identify the point of contact to whom you should submit an agency protest, or the point of contact specifically for submitting certain types of proposals. So those sorts of things, what I would call they're important details, who to go to, what might be a specific, difference in terms of number of days or specificities where the FAR may be a little bit vague or leave it open to agency tailoring. Those are important details, but we are not going to cover each and every one of those today. Today's goal is going to focus on what I would consider to be the major deltas in terms of where the NRCAR truly supplements or modifies the FAR, reflecting the Nuclear Regulatory Commission's unique mission. So you'll see that we have a more tailored agenda for this afternoon. Next slide, please. To get oriented, the numbering scheme for the NRCAR, as do the other FAR supplements, reflects the chapter of the CFR where this is located. So I mentioned that the NRCAR is codified at 48 CFR Chapter 20. So what that means is, as we go through the NRCAR, everything is going to have a 20 or an extra 0, a 200 in front of the numbering scheme, the FAR numbering scheme, so that we can track the FAR number that we're relating back to. So, for example, if we're supplementing FAR 1.104-1, the NRCAR number will be 2001.104-1. So you'll see that extra 20 in front of the leading number, or the 200 in front of the leading number. Similarly, FAR 24.1 translates over to NRCAR 2024.1. So on the front side, that's how you'll always know when you're going through a solicitation or a contract which agency you're dealing with or which set of agency regulations you're dealing with. Is you'll see the FAR, but if you see that 20 or 200 in front of a number, that's going to tell you that you're in the realm of the NRCAR. Similarly, when you're looking at contract clauses, the way that the unique NRCAR clauses are designated is with a numbering scheme of 70 or above. So, for example, in the 52 provisions, you'll see that the NRCAR security clause is numbered with that leading 20, so 2052.204, and then it's got a -70 as the clause number. The subsequent clause is -71. So that as you're looking at clauses or contracts or solicitations, will help guide you in terms of, are we dealing with which regulation are we dealing with? Are we dealing with supplemental or different clauses, or something that is much more closely tailored or analogous to the FAR? Next slide, please. This slide lays out the contracting authority chain within the Nuclear Regulatory Commission. So the contracting authority is vested in the Nuclear Regulatory Commission chairman, and that's defined in NRCAR 2001.601. The way the chain then goes is the chairman has delegated authority down to the executive director for operations, who has delegated contracting authority down to the deputy executive director for management services, who then in turn has delegated authority to the director of office of administration, then down to the director of division of contracts and property management, who in that role is responsible for specific contracting officer appointments and managing the contracting function. You'll see the colored stars there, and that relates to some of the key positions and delegated roles that you see in the NRC organization. So as most of you know, when you look at a FAR or an agency supplemental clause, a lot of times, there are rules, but every rule or many rules have exceptions or waiver opportunities. And the supplement will identify to whom a particular waiver or exception has to be escalated in order for it to be approved. And so in this case, one of the key roles in approval or waiver processes is the head of the agency. In the NRC situation, that is the executive director for operations. Similarly, there is an important role for the senior procurement executive. And in this case, that is the Deputy Executive Director for Management Services, who also serves as the agency's suspension and debarment official. And then finally, the head of the contracting agency, or the HCA, as you sometimes see referenced in the FAR and some of the supplements, we were informed in NRCAR 2002.100 that role is for the NRC is the Director, Division of Contracts and Property Management. So this gives you a sense of, the contracting officer for purposes of contracting and procurement and solicitations will be your first line of defense and is the master of the contract. But as unique situations come up, or as you're looking to escalate issues or questions or potentially request waivers, you can see how that chain works its way up and who some of the key players are from an organizational perspective. Next slide, please. So as I mentioned, we're not going to go through every segment of the NRCAR today. We're going to focus on the 5 areas that, as I was going through the regulations and looking at them, really jumped out at me as being the areas of the most either tailoring or really stood out as the NRC has made significant efforts to really either emphasize or tailor these rules and the FAR regulations, or add new regulations as compared to the FAR. So you'll see the 5 categories that we'll talk about for the rest of today will be conflicts of interest, current and former agency employee involvement, accelerated task order procedures, a non-discrimination because of age provision, and then a provision relating to differing professional views. And we'll take each of these in turn. We'll spend the most time on the conflicts of interest policy, in part because it's the lengthiest. If you look at the NRCAR itself in terms of the clauses and the sections, this is where the majority of the tailoring and the beefiest clauses are found. We'll spend the majority of our time talking about conflicts of interest, and then we'll touch on each of the others. And then we'll wrap with just a few quick hit observations from a few different provisions as well. Next slide, please. So with respect to conflicts of interest, it was really interesting to me, and it always has been, looking at the NRC regs, that the NRC is uniquely concerned. Every agency is concerned about conflicts of interest, but the NRC is uniquely concerned about not just explaining conflicts of interest, but identifying them and really providing examples and going what I would say above and beyond what most agencies go into in terms of what constitutes a potential conflict and imposing additional rules around how to mitigate and how to identify conflicts. One of the things the agency requires are detailed disclosures and representations by offerers relating to potential and actual OCIs. Now, again, every agency does this, but I think you'll see as we go through these provisions the extra level of emphasis and detail that we see is unique, I think, within the NRC, and it makes sense when you think about the agency's mission and role and the sensitivity of the information that it's dealing with. The other thing that's interesting, though, is I think the agency clearly recognizes that with these heightened concerns and heightened disclosure obligations, there needs to be heightened methods for addressing and looking for reasonable but appropriate mitigations. And so we'll see those as well. One of those mitigations that I think was interesting is that where an offerer believes that an actual or potential OCI exists, the regulation specifically allows offerers to propose an alternate proposal. So to say, the RFP has provided a certain scope, but we believe that there might be a conflict with this small portion of that scope, so we'd like to propose to do the work but exclude this small portion of the scope that otherwise would create a conflict. So the agency provides opportunities during the formation process to carve out pieces of work where conflicts might arise and propose an alternate scope that would eliminate the conflict. Obviously, that may or may not work for the agency. That may or may not be a way the agency can achieve its mission in a reasonable and efficient manner. And depending on the number of bidders and things like that, the NRC certainly retains the right to reject those alternate approaches. But the fact that the regulations specifically allow for that sort of I would say, creative alternative proposal approach, again, just sort of underscores the agency's mentality with respect to taking OCIs very seriously, but trying to be reasonable about them as well. Next slide. So subpart 2009.5 of the NRCAR talks through the specific organizational conflict of interest concerns. And as I talked about, it requires contractors to specifically disclose a heightened level of information and circumstances that could give rise to an OCI. So some of these would be, I think, fairly logical extensions of what's already in the FAR, but just articulated in more detail. So for example, if a contractor is providing advice and recommendations to the NRC in a same area where it's providing consulting to an organization that the NRC regulates, then that's a potential conflict that requires disclosure. Similarly, if you're going to work for both the NRC and a regulated organization on the same or similar work, that makes sense as well. That I think these are sort of natural extensions of the FAR, or where award of a contract could place the contractor in a conflicting role where it might have biased judgment or result in unfair competitive advantage. Again, those are concepts that come directly out of the FAR. But one of the things I want to highlight for you here is Romanet 5 down at the bottom, that a disclosure is required when a contractor solicits or performs work at an applicant or licensee site while performing work in the same technical area for the NRC at the same site. So this goes, again, it's not out of the realm of the FAR, but I think it goes a step further in articulating that it can simply be the nexus, the only nexus that we see here in this Roman 5 is the location. So you're simply at the same location. That alone, even if the work doesn't overlap, that could create a conflict. And we'll see that in some of the implementing regulations and contract clauses a little bit later. And certainly if you're doing work in the same technical area. Next slide, please. One of the mitigations, so that we'll talk through now, this is Contract Clause 2052.209-71, which is the implementing clause that gets incorporated into NRC contracts relating to conflicts of interest. And again, we're not going to go through every provision of this clause, but we are going to talk about a number of the subparagraphs where again, I think the NRC has gone into specific effort to identify and provide examples and clarify its view of what can create a conflict and how to mitigate. One of those paragraphs here, paragraph C, is called Work for Others, and this is one of the mitigation paragraphs. And you can see that one of the things contractors sign up to in agreeing to do work with the NRC is that during the term of the contract, the contractor agrees to forego entering into consulting or other contractual arrangements with any firm or organization which may give rise to a conflict of interest with respect to the work being performed under the contract. Again, I don't think this is necessarily a sea change from what the FAR articulates, but it does go above and beyond in saying we're not just looking at conflicts at the time of formation, but we want to make very clear that the contractor, in working with the NRC, has to be vigilant looking forward and take active efforts to ensure that you don't create conflicts in subsequent contracting opportunities if you're awarded a contract by the agency. Next slide. This clause goes on to say there are specific examples as to what the contractor may or may not do with respect to relationships with NRC licenses or applicants and those utilities that are regulated by the NRC. But in particular, you can see that subparagraph 3 of this Work for Others clause down at the bottom indicates that when the contractor performs work for the NRC at any NRC licensee or applicant site, the contractor shall neither solicit nor perform work in the same or similar technical area for that licensee or applicant organization. That makes sense, right? Again, that sort of relates back to what we were just talking about. You can't go and accept an NRC contract and then take on work that's going to create a conflict after that. What's interesting about this, and I think where the NRC does then sort of take additional steps, is it's not just for a period commencing with the award of the task order. Again, that is somewhat logical and a natural extension of the FAR, but it extends to 1 year after completion of all work. So it's not just during the period of performance of the work that the NRC is imposing these restrictions, but also in this case, and you'll see some different periods in some of the other clauses, this goes on, this prohibition on work goes after 1 year from completion. And so not just during the term of the contract, but for a year afterwards, not only can you not perform work for that might create a conflict, you can't solicit work either. So there's a prohibition that extends, so you can't even begin to talk about follow-on work until more than a year after contract completion. Next slide. Similarly, you can see that the contract this gets further implemented and reiterated here in subparagraph 4 and Roman 2. Again, you see again the contractor may not perform work at the site during the period of performance or for 1 year thereafter. So you've got this time-based prohibition. Next slide. Moving out of the work for others provision and into some of the other paragraphs of the OCI implementing clause, you can see again the NRC here is talking about what happens where the contractor obtains access to information, NRC information, such as plans, internal data protected by the Privacy Act or subject to withhold under the Freedom of Information Act, information that's not typically publicly available. Again, you see some of the standard FAR prohibitions, things like you can't use the government-provided information for any purpose, any private purpose, until the information becomes public. You can't release the information without contracting officer approval. Those are things that we see as natural extensions of the FAR. But Romanet 2 and Romanet 3, again, I think provide some extra meat on the bone in terms of concerns and restrictions imposed on NRC contractors. If you as an NRC contractor receive access to non-public sensitive NRC information, you are not permitted to compete for work for the NRC based on the information you receive for 6 months after completion of the contract or release of the information to the public, whichever comes first. So if the information continues to be held as sensitive, again, you see this 6 month period tagged on to the end of the contract that adds an additional prohibition in terms of being able to solicit work. What's interesting about this to me, as well as in Romanet 3, is that we're talking about limitations, not just on using or soliciting work with third parties, which certainly makes sense, but there's an even more heightened sensitivity, and you can't compete for work with the NRC itself. So it's not a matter necessarily of disclosing improper information, but the NRC is concerned about unfair competitive advantages or improper bias or judgmental impairment. So Romanet 3 is along those same lines and says that the contractor in this situation is prohibited from submitting even an unsolicited proposal to the government based on this non-public information until after the release of the information to the public. So it's interesting. You can see the sensitivities here that the NRC has, and the lengths it's going to not just ensure that there's not third-party inadvertent disclosure, but they're trying to neutralize the risk of impaired objectivity or bias. Next slide, please. One of the great things that the NRCAR does is it provides a detailed number of illustrative examples of how does all this language, which can be a little dense and hard to follow, how does that play out in reality? And we're not going to go through every single one of the examples. I think there are 9 in total in the regulations, but I've got 4 here that I think capture some expected and some sort of more interesting outcomes in terms of what you might expect from OCI clauses. So this first example, the ABC Corp, in response to an RFP, proposes to undertake certain analyses of a reactor component for the NRC. The ABC Corp is one of several companies that are considered to be technically qualified, and so they decide to submit a bid in response to a competitive acquisition. In its proposal, the ABC Corp advises that it is currently performing similar analyses for the reactor manufacturer itself. In this example, the NRC says that normally this contractor would not be allowed to be awarded the contract. And the concern is that the company, because it's doing work already for the reactor manufacturer, could be in a position to have biased judgment with respect to its NRC analysis. And because there are other competitively qualified tech companies who can do this work, the NRC has said it doesn't see that in this scenario it makes sense to take on the risk of a conflict when there are other qualified bidders. So in this scenario, the bidder would probably not be qualified to perform. Next slide. The second example is the longest one, so I apologize for the eye chart. But in this example, the company decides to submit a proposal for a system to evaluate a specific reactor's component performance. And the purpose of this analysis and evaluation is to help the NRC develop some important internal standards. So you're doing standards and specification development. In this case, the ABC Corp has also advised the NRC that once the system has been developed, it would like to sell that system to the industry and say, you know, here's how you can go do the same evaluation on your own commercial components. Other companies in this business, though, are using older systems for evaluation, whereas what the ABC Corp is proposing is a new and novel system to do this evaluation. In this case, even though there is some potential conflict, the NRC has said that the contract could be awarded to the ABC Corporation, in part because it is providing a unique and novel technology that's not otherwise available in the market. But the guidance says that there will need to be certain types of mitigations put in place into the contract. So, for example, the awarded contract to ABC has to say that no information will be used in the contractor's private activities unless this information has been reported to the NRC. So ABC Corp doesn't have free rein to just go use the information it's developed. It has to explain what it's going to do to the NRC and go through some form of a screening and approval process. In response to that, what the NRC plans to do, and one way it looks to mitigate and level the playing field, is the NRC will probably take a lot of that information that only ABC Corp would have access to and disseminate it to others in the industry. And what that does is level the playing field if others want to, go create their own novel system using the same data. And then finally, the contract will stipulate that the contractor will inform the NRC contracting officer of all situations in which the information developed about the performance is proposed to be used. Again, you have this information screening process and disclosure process that's defined so that the NRC has the ability to decide what, if anything, needs to be disseminated so that other competitors in the industry have the same opportunity. Next slide. The third example is a little more straightforward. It says the ABC Corp, in response to an NRC RFP, proposes to assemble a map showing certain seismological features of the Appalachian Fold Belt. As part of its OCI's disclosure, ABC informs the NRC that it is also in parallel doing seismological studies for other utilities in the eastern United States. But that none of them are in that same Appalachian Fold Belt. So it's doing similar work for the industry, but in a different geographic context. In this case, the NRC guidance says that should be fine for the most part. In most circumstances, because the geographies are different, that there's little risk of biased judgment or conflict. And so even though there's overlap in work type, this is not a problem. Next slide, please. But the final example is, I think, a particularly interesting one, especially in contrast to what we just talked about. In this example, ABC Corp is constructing a turbine building and installing new turbines at a reactor site. The contract with the turbine reactor, or the contract for this installation at the reactor site is with a utility, so a private entity, and is for 5 years for a total value of $100 million. In parallel, ABC has submitted a proposal to the NRC to participate in a major inspection at that same utility site, but the inspection is completely unrelated to the turbine work. So it's inspection of a completely different set of components, subsystems, would have no technical overlap with the work being done by ABC under its contract with the reactor site. The estimated contract value with the NRC is about $75,000. What's really interesting to me about this is you look at it, and in this case, the NRC comes down and says, this type of contract situation would typically not be allowed. And in this case, the NRC would say that ABC has a potential conflict that is substantial enough that it would not award or would not consider ABC qualified for this award. And the reason for that is because even though the work is completely unrelated, technically, the fact that you look at the relative value of monetary value of these contracts, $100 million paid by the utility versus $75,000 paid, which would be paid by the government, that there is the potential for a financial loyalty to the higher paying customer, the utility, that might cause the contractor to have bias in its judgment and its assessment and inspection for the government. And so the fact that this unrelated work creates a financial risk of essentially financial bias. You want to please the customer that's going to pay you the higher amount, especially when you see this level of disparity. In this type of situation, the NRC would probably say, thanks, but we don't consider you to be qualified for this one. So this, I thought, was a particularly interesting example because, again, it's not out of the realm of reason by any means, but it definitely goes farther than the FAR does in terms of specifying, a type of conflict that doesn't, I would say, naturally or logically arise, immediately when you think about conflicts of interest under the FAR. And the agency is really trying to, I think, be transparent here with its potential contracting base and say, look, we are serious about this. We really do look at this and think this is important and want to make sure that we're being mindful of scenarios that could very reasonably arise, but may not be necessarily intuitive. So that wraps up the examples. Next slide, please. Just to finish up here with the conflict of interest before we move on to the next sections, there's the ways to mitigate. So to the extent you have a conflict of interest under that gets disclosed, we saw some examples where some of those couldn't be mitigated, but some of them can be potentially. And so NRCar 2009.570-5B provides some of the possibilities for how those mitigations could be set up. So the contracting officer is empowered to include special contract clauses that are tailored to the circumstance to figure out how best to treat the situation. That may mean that you're limiting certain types of hardware, provisions in terms of production contracts versus development contracts. It could be similar to their software exclusions. There could be key personnel limitations or firewall obligations, things along those lines. It's the normal, I would say, toolkit that the government has and industry has in terms of figuring out what's best, but the NRCar sort of identifies that for industry and the government specifically. Next slide, please. And then finally, 2 points on conflicts. As we've talked about and as you've seen through the regulations, the NRC is not just worried about conflicts and conflict assessment at the time of contract formation, but they are also concerned about keeping an eye on that and preventing future conflicts once that may arise in parallel with the performance of an NRC contract. And so there is a contract obligation, an ongoing obligation by the contractor to monitor, report, avoid conflicts after award. If those things arise, and the contractor discloses them, there is an opportunity for mitigation conversations in the same vein as we've just talked through, some of which may be acceptable, some of which may not. And then the last point, which is interesting, is the Remedies Provision in 2009.570-10, which says that specifically the NRC may debar a contractor from subsequent NRC contracts for breach of the OCI restrictions. And so this, I think, just is the nail in the point of the NRC is taking this very, very seriously. So in addition to the standard suspension, debarment justifications, things like substantial overpayments or failure to make a mandatory disclosure or other things along those lines, the NRC has specifically said that OCI violations, in its opinion, is sufficient to rise to the level of a debarment justification. So don't underestimate the importance of these OCI provisions to the NRC. Next slide. So the second topic then, having wrapped up conflicts, is actually an extension. It's a separate provision, but it's an extension in a way of this conflict topic. And this is relating to current and former agency employee involvement. Along the lines of avoiding conflicts with contractors, the NRC is concerned about avoiding conflicts created by former personnel leaving the government and then going to industry. And as most of us know, there already is a set of overarching government ethics rules for former government employees. You see that in the government ethics rules at 5 CFR 2635. But one of the things that the NRC regulations do is go into more detail and specifically say, you can see here, it is NRC policy that only competitively awarded contracts shall be placed with an individual who is employed by the NRC within 2 years from the date of the request for procurement action. So essentially, NRC personnel, on top of their government ethics, general government ethics restrictions, have a 2-year cooling off period for any non-competitive contract award made by the NRC. And you can see that it's not just individuals acting as independent contractors, for example, but companies where the NRC employee has a dominant ownership interest, a dominant management interest, or is a key personnel or other critical designated employee like a principal investigator who will do a more than nominal amount of work under a contract. So as a contractor, I would encourage you to, as part of your your revolving door screening, so to speak, if you're doing NRC contract work or looking to do that, understand that it's probably worth some heightened diligence, both for the company and for the government employee or the former government employee as well, to make sure that everyone understands what those timelines and restrictions and potential work assignments look like. Next slide, please. We've pretty much talked through this, but you can see that this slide has the implementing provision and some of the key language. So, and paragraph A of the contract clause specifically informs contractors that the use of former NRC employees may adversely affect your consideration in a non-competitive proposal. You can also see in paragraph B here that there's a specific representation that's required. Are there any former or current NRC employees who have or will be involved in the offer or in the proposal? And if so, you have to provide some very specific information about who they are, what their role is, what was their title, is their title if they're still employed, what would their role be. So again, the government has enough information to evaluate the potential conflict. Next slide. The next topic that jumps out, this is a little less, I would say, a little less different in terms of some of the other things that we've seen. But there's an accelerated task order procedure clause that essentially creates the opportunity for an undefinitized contract action at the task order level. So we all know that in the FAR, the government in certain circumstances has the ability to authorize contract performance to begin via a letter contract, even though things like the price may not have been fully defined or the terms may not be fully negotiated. But the government can authorize work to begin so long as the contract is negotiated and definitized within a certain amount of time. The NR card has that similar type of provision for task orders, with similar restrictions around the work has to be definitized within a certain amount of time and things like that. But the other thing that I think is interesting about this provision in paragraph A, as you can see, that the contractor may verbally authorize the work. Verbal contracting actions are very unusual in the world of government contracts. You only really see them at the micro purchase level under FAR Part 13. Here, there is no dollar limitation. And so it's a recognition, I think, that the NRC has or anticipates the possibility of time-critical work that has to begin. And so they've gone further than the FAR does in authorizing the contracting officer to provide a verbal authorization for work, but then providing the procedures around that to definitize within a certain amount of time. Next slide. This next provision, though, is completely beyond the scope of the FAR in terms of language. It's certainly not, I think, beyond the scope of normal employment law. But we're used to, in the FAR provisions, seeing language around non-discrimination relating to certain protected classes, such as race, national origin, gender identity, things along those lines. We don't have in the FAR an specific age discrimination clause, but the NR card does. And you can see the implementing provision and then the contract clause itself. And it doesn't say anything, I think, mind-blowing. It simply says that contractors and subcontractors may not, in the employment, advancement, or discharge of employees in performance of a contract, discriminate against someone because of their age. Certainly, you can still hire, fire, or advance someone for reasons other than their age, regardless of their age status. But the NRC has a specific protection for age discrimination. I actually went back and looked at the implementing final rules and things like that to see if there was a particular description as to why they included this specifically, whereas the other regulations don't. And I didn't find an explanation. I'm curious about that, although I've not fully dug into the statute. But I thought this was an interesting emphasis by the NRC in terms of its priorities. Next slide. And then to wrap up, the final specific clause that we'll talk through is another interesting one that I think is unique amongst the NRC. And it's a clause called differing professional views. And you can see the bold language here, which is unique amongst agencies as far as I'm aware. It says that the NRC policy supports contractors' expression of professional health and safety related concerns associated with the contractor's work for the NRC that may differ from a prevailing NRC staff view, disagree with an NRC decision or policy position, or take issue with proposed or established agency practices. So this is an express acknowledgement and even solicitation by the NRC to, for respectful disagreement and challenging of policies and procedures by its contractors, which, I think is phenomenal. I think it's a great thing for an agency to say, we may think we're doing the right thing, but we respect and we want contractors to feel like you need to come tell us if you think that we're not doing something right or it could be done better. There's a whole procedure for submitting this and resolving it, which we'll talk about in a minute. But the fact that this clause is there, I think, in and of itself is as I said, unique amongst agencies. Next slide, please. So the procedure for resolving differing professional views is outlined in Contract Clause 2052.242-71. Subparagraph A specifies that this applies to subcontractors as well. So subcontractor DPVs have to be submitted through the prime contractor and up the contracting chain. But it says that the prime contractor shall submit all DPVs received. So this is not a discretionary thing where the sub can submit to the prime and the prime can say, you know what, I don't want to rankle the customer, or I don't think this is worthy of submitting. The prime or the higher tier subcontractor has an obligation to pass this up through the chain to the NRC. That said, the higher tier contractor doesn't have the obligation to endorse that recommendation. So I as a prime, could submit this and say, this came from so-and-so subcontractor, NRC contracting officer, but, do with it as you will. I don't necessarily agree with it. And that's fully acceptable as well. The other thing that I think is interesting and underscores the NRC's commitment to this is paragraph B, which says that the NRC may authorize up to 8 reimbursable hours for the contractor to document a DPV. So if there is a DPV and the contractor says, hey, I want to go do this, and I'd like to get reimbursed for it, or our subcontractor would like to get reimbursed for it, there is a mechanism to add money and add time and hours to a contract to authorize that. At any time, the rule is always the case that the contractor is, or the government is only obligated up to the amount of the contract funds obligated. So if a contractor decides to move forward with a DPV, beyond their contract ceiling, that's at their own risk. But the fact is that the NRC can add money and authorize the time to make those allowable costs, which again, I think underscores their commitment to this. And then paragraph F just talks through what is included in the DPV, which is essentially a summary of what's the current position, what is the description and summary of the differing position and why, and then the rationale. What is it that makes the current prevailing position worthy of reconsideration? Next slide, please. The timeline for review is this gets submitted up through, if you're a subcontractor, up through the prime, and then ultimately up to the NRC, as we talked about. This gets submitted to a panel at the NRC who will provide an initial 7-day review to decide whether there's more information that needs to be provided. But then within 30 days of the initial submission, the panel will provide a written recommendation to the office director or regional administrator within the NRC, as well as to the contracting officer with the panel's recommendation and an assessment of the DPV. And then within 7 days of receiving the panel's recommendation, the office director or the regional administrator will make a decision and issue a written decision to the contractor in terms of what the final outcome is. So that's the process. It's fairly routine, but again, the government it doesn't always do this, and as we see in the FAR and in other types of procedural reviews, there are specific timelines associated with this. So the government, this isn't something that gets submitted and disappears into a black hole, but rather sits within specific timelines for the government to review and disposition. Next slide. So the last thing we'll touch on are just 3 very quick provisions that again probably don't need a lot of time, but are unique within the NRC. The first is the disputes provision. The Contract Disputes Act still applies, and the FAR provisions and process still applies. But what's interesting about this is that there is a special board, the Department of Energy Board of Contract Appeals, that hears the NRC-related disputes. As many of you probably know, there used to be every civilian agency and every agency, for the most part, had their own disparate individual boards of contract appeals. The Department of Agriculture had their own. The IRS had their own. There were whole independent sets of boards. But a number of years ago, the vast majority of civilian agency boards were consolidated down into the Civilian Board of Contract Appeals. But here the EBCA still stands alone as a standalone Board of Appeals review, and the NRC is in an interagency agreement to review that, to participate in that. The next clause is the Freedom of Information Act. The only thing of note here is that the provisions of 10 CFR Part 9, Subpart A, apply to determining the releasability of NRC records. So in addition to the standard FOIA rules, if you're looking at FOIA requests related to the NRC, you want to go look at this specific part of the CFR. And then finally, travel approvals and requirements and reimbursements. This is just a note that all foreign travel must be approved in advance by the NRC. So even if it's within the contract scope, it has to be submitted 30 days before travel, approved in advance. And I think that's just a reflection of again, the agency's very sensitive mission and the nature of the information it's dealing with, and wanting to keep very close tabs on where where people who might possess that information are going and what they're doing. So not surprising, but just worth noting if you're doing business with the NRC. And with that wraps up our discussion of the NR-CAR today. Again, there are a number of other provisions within the NR-CAR that if you're doing business or looking to do business with the NRC, you certainly should go look at, and I highly recommend. But I think, as I said, these are the ones that just really jumped out at me as being a little different or a little over and above what you would see or expect out of the FAR, and make the NRC regulations, I think, unique in terms of supplemental content. So thank you very much. Appreciate your participation, and please do not hesitate to reach out if you have any questions. Thank you.
Thank you, Erin, again, for such a great presentation. As she said, if you have any questions, her contact information is there on the screen. And thank you to everyone who participated. The recording and slides from today's webinar will be available within the next 24 hours or so. So be on the lookout for that. And we look forward to seeing you on Friday as we go through the playbook for the NRC. The registration link, as always, is on our website. So this will conclude the webinar. Have a great rest of your day, and thank you for attending.